Hey everyone, I hope you guys are doing well. Um, I wanted to make a live because a lot of folks is having problems in this category, and the subject is how to stop eviction collections. So when it comes down now to a lot of past due collections for rents that's due or certain fees when it came from a contract from an apartment, a lot of people are seeing an uptick on these collections as from these kind of contracts moving out of an apartment. So before, you will see a lot of times the eviction as a public record, but now you have debt buyers that is kind of exclusively purchasing those kind of debts, that if you moved out of a apartment, had past due rents, if you moved out of an apartment and it might have been some damages, that now those buildings or companies you rented from are selling those debts and have these collection companies to now pursue you. Debts like this can turn into a lawsuit by that third party collection company. So I have been working with people, and this could be like a number of years ago, and now you will see a collection pop up from an apartment building. And when that happens, a lot of times it really hinders your chance of being able to rent again. It really does, especially with a building that is more or less on a commercial side, maybe than a private landlord. And even now, private landlords are running the credit reports, and they're seeing that you have a prior basically issue, even if it's not an eviction, a collection. So you might have not even went through the court process and been evicted, but because that landlord, that company you rented from, saying that you owe a past balance, they're selling that to a collection company. So how would you attack this? These kind of collections are really interesting because they are subject to your state laws, state by state. Every state, now keep in mind, I'm giving you information from me being a landlord and knowing this knowledge, but I am not an attorney. So if you are having these problems, I'm giving you a general knowledge of things on how you can fight this that will pertain in questions you will ask an attorney. But if you are having legal issues, remember, I'm not an attorney and this does not constitute legal advice. But when it comes down to these collections, one thing is going to be basic. You want them to validate the debt. One of the items that is imperative to this collection that need to be obtained is that lease agreement that you had with that prior building. That lease agreement can surely be your way of really, how you doing, Mr. Williams? One of your ways to really get your way out of this and fight this legally. And I'm just coming from me being a landlord, and certain loopholes you really need to attack, especially because these companies are a third party. Okay? So one of the things you will need to request when you make them validate that debt, if you don't know, debt validation is your right under the federal law, the Fair Debt Collection Practices Act. So one of the things they're going to have to produce is that signed lease agreement between you and that original creditor or your original landlord. You would need that signed lease agreement. In that agreement, you need to also demand from them where's the section or where is their right that you gave that landlord to sell that debt. Understand, when you created that lease agreement, you had to give permission for that debt to be sold. So if that is not in that contract, that third party does not have a legal right to collect on that debt. Second part, there are many times when it comes into a lot of states, in order for a LLC or a outside company to collect on rents, you have to be a licensed realtor. In the state of New Jersey, no one, a manager, you have to be a licensed realtor to collect rent. You need to ask your attorney in that state, how is that being handled? Is that company even allowed to approach you or even pursue you for a lease agreement, a residential lease agreement? So these are some things you need to inquire about. Also, in that contract, which would be your lease agreement, the fees that you're being charged for, you need to see if those fees are in your lease. If those fees are not in your lease, like late fees that they are alleging that is in that contract or it's part of that debt, how are they coming to the number that they're saying that you owe? Did you sign that lease, and are those late fees actually in that contract? You cannot be charged for those late fees if they're not in that contract. You cannot, in most states, be charged for lawyer fees if there are if it's not in that contract, or filing fees. So if they are actually reporting this debt against you, this third party, and they don't have a legal right to collect, and all of that is inaccurate, they're actually causing damage to you, and you have a right to turn around and sue them for defamation of character. Another big part when it comes down to landlord-tenant issues, with that debt validation, you need to also research your laws, the landlord-tenant laws. Your best avenue is talk to an attorney, because they will know the laws in your state. With an attorney, you can find out what is the statute of limitations. Many times when it comes to a debt, there's a limited time that that debt can be pursued. If that is a old apartment that you had many years ago, 5 years ago, you need to investigate, can that debt even be pursued anymore? Many states already have a statute of limitation that a debt can be pursued. So you need to find out what is that limitation for your state. Furthermore, another key, in the state of New Jersey I'm in, if you have a lease agreement, you leave that apartment get rented the next month, that landlord could not charge you for all the months that's left on that lease agreement for what you owe. In my state, they can only charge you for when they rented that apartment. If that is the same in your state, you need to find out by talking to an attorney to find, are they able to charge you for the full amount of that lease, those additional months. So some of that is in your statutory law and have absolutely nothing to do with the lease, whether they put that in the lease or not. The statutory law many times may not allow them to do that. Another part, you want to see if they wrote you about the damages and where they applied your security deposit with the damages. Many states require them to give you notice in a particular amount of time that when you moved out, what was their obligation of notifying you on what the damages are, what they're charging you for, and where they applied that security deposit. Whether you had back rent or not, many times that landlord is still required to send you a notice of what they did, usually by certified mail. Another key point though, if you did move, you needed to sometimes to get that security deposit back or get those notices, you were supposed to notify them where you were moving to. Or they might have just simply sent that notice directly to where you lived. And if you did not forward, or the apartment that you left, if you did not forward that mail, then you didn't receive notice. But you should still demand that to be produced. All of these items that I'm naming for you is very difficult for a third party to be able to have that information from a old apartment that you allegedly owe rent for. So they have to even give you a breakdown. So this is not like credit card debt when it comes down to evictions or apartment collections, because they have to be very specific. This does not accrue interest that they can charge you for interest. It has to be a flat fee. So if you think about it, you need to really walk it through and look at these steps for finding this information, because it could, with these landlord tenant laws, with these companies out of state, if they don't have, I know certain states, you got to be a licensed realtor. Are they even set up to do that kind of collection for an apartment in your state without being a licensed realtor? So you want to keep in mind when you call these companies on the phone to be very careful what you're saying, because if you begin to, because you're under the gun to remove it, try to get another place, and this is a hindrance, you could possibly, by speaking to them, begin to build a verbal contract with that company. If you start to say, hey, I'll pay you $25, then now not only could you possibly build a verbal contract, because they do record these calls, but you could also reactivate the statute of limitations. So you want to be careful with that. One of the main goals for you when you're handling this is the demand that they're being compliant to your state laws. Also, you can demand the proof of your payment history there at that property. Demand for your checks. Where's the payment, complete payment history? The whole time I lived there. The fees, where's the breakdown for what month I owed late fees. I want my total accounting for this debt that you're saying that I owe. Many times they don't have that. And they're not, probably, it's very rare if they're going to have that, because they have to go to that prior company. And one of the most important things you have to see, did they legally buy that debt? So you can purchase a debt. I can purchase an item off the street corner from someone who maybe stole it and sold it to me, but that don't mean I had clear title because of the means that they got that was by illegal means, or jewelry by illegal means. Same thing with these debts. From your state, was they able to even sell that? Many a times with these buildings, landlord buildings, if they took a loss on that debt, themselves personally can't claim or come after you for that if they took a loss. So their legal entitlement to get involved to come back after you will have to be seen. So this outside company, which you never had any dealings with, is going to have a real tough time. And they must make sure that they're compliant of that state law, even certain compliance if they have to have certain licensing to even operate as a landlord. If they have certifications, you can really make a mess and demand a number of items from that company that they will rarely be able to be produced. So you may have certain times when that kind of debt is then sold back to an attorney company in your state. And that attorney company could just be a debt buyer, unbeknownst to you, that it might look like that collection have gotten an attorney to fight for them. That could be possible, but many times that attorney actually owned that debt, and he's making an appearance that he is actually fighting for this company when it's his own debt. When you have those scenarios, it is very important for you to begin to look at the items that I just named, far as the original lease agreement, looking at whether those late fees are included, lawyer fees. If a suit is initiated against you, number one thing that you need to look at and ask for is the items that I named. Because if that amount is beyond what you owe, then that is defaming your character. That is costing you financial loss. So you can also hold the company that they are naming, that they're representing, their CEOs, vice president, employees that make business decisions for that company and the company itself, liable for defamation of character because they're lying on you. You don't owe that debt. Even if the debt is owed, it wasn't accurate and it's being reported on my credit report. So you could either initiate a lawsuit if they refuse to give you those items. And furthermore, if they did initiate the lawsuit, you make sure you always countersue and they will dissolve that debt. You just gotta make sure you talk to an attorney. If y'all need access to an attorney service, give me a call. I use this as leverage many a times to clear up my credit. If you don't know, if you haven't followed my information, you know that's a lot of people stray away, but the small claims court is an effective tool to clean up a lot of things off your credit report if you have legal counsel. So I have means, I have accesses and resources where you will be able to talk to a attorney that's in your state. So a real law group, a real law firm that would give you accurate information pertaining these kinds of suits. So you just got to make sure that you ask the right questions. You got to make sure if any lawsuit that you guys have been hit with, whether it be consumer debt, which is like debt from credit cards, debt from a lease, you want to always make sure, medical debts, that the jurisdiction is even right. They have to serve you where you live, in the county, many times where you live. So it may vary state by state, but you need to look into that. Jurisdiction, did they serve you not only where they should have served you, in your county or in a certain district, but did they also serve you correctly? There are many times that if you have a certain amount of debt, there's a breaking point from it being special civil to civil part. And there's different requirements that they have to give you notice that there's a suit. So you always want to ask an attorney, how should they serve me? If they served your cousin, if they served a child under a certain age group, sometimes that's illegal in your state. It is not a good service. So if that wasn't served in the right jurisdiction, in the right way, it can be dismissed. You can move to have that dismissed. But it is very important you talk to an attorney in your state, because this is always in particular to each state. And you must ask them, what is the landlord-tenant laws? The landlord-tenant court is a much different court. It's a different law from when you got evicted. And then now they're taking you to civil court from a landlord-tenant issue. So keep that in mind. I hope this information for you guys is valuable, because some of those, if you really challenge it the way that I'm telling you to challenge it, you will have good success with these. If you need to have a debt validation letter, just like some of the information I lined up for you, feel free to go to my website. And what you want to look for under the pricing page, the Deluxe collection package. Send out the one for the consumer debt. Make them validated. But the original contract that they have to send back is not a bill. It's going to have to be your lease agreement. That is what all of this is based on. So anything out of that scope that they're trying to charge you for, they have to give you a breakdown. Because remember, these kind of debts is just not debts with interest. It is just a landlord-tenant contract, and it doesn't have interest. It's not like a car loan. It's not like a medical debt. It should not be increasing in the price every month of what you owe. How is it accruing interest, or what are the fees they're charging you? And even certain repairs have to be in the contract. Always remember, with some damages, the law already said if you're living in a unit, there's going to be certain wear and tear to that unit. So if the carpet is slightly worn down, that's just part of living in the unit. So some things are just wear and tear. Now, if you have other items that you're clogging up the toilet, or your children call it, that's not regular wear or tear. But it has to be somewhere in that contract where it breaks down. Where are the repairs? Who are responsible for the repairs? If it's leftover utilities, who was responsible for the utilities? It has to be broken down. So keep those things in mind. I talked to a friend, and I'm like, some of these things blow my mind. She was saying that the landlord in a 3-family apartment unit said they were responsible for the grass cutting, which is ridiculous. Why would you in a 3-unit building be responsible for having the grass cut? You personally in that rental unit. That is really unusual. You want to make sure you check that lease. Okay, so you have to make sure of that, because if That landlord said part of that, what you're charged, is from not maintaining water, not maintaining lights. You got to make sure you look at your contract. Was you even responsible for that? You need to look at your state laws. Was that even a responsibility you should have been carrying? So certain buildings do have their own individual water meter, but if that's not the case, how were you responsible for these items? And how were you responsible for these damages if they are reasonable damages, or if the product was not made correctly? How are you being charged for that? And where was the notice? If they were other items, when did they notify you that these items was damaged by you? So keep in mind. Also, you can demand, where's the replacement? Where's the receipts for the repairs? So you can also demand that in court. If they bring that up and you demand for an attorney, or you can demand that yourself with a guidance of an attorney, if they're saying repairs, to demand that they produce those repairs were actually paid for and done. So I hope this information is helpful to everyone. If you enjoy the content, please like and subscribe to this YouTube channel. If you need to contact me because you are facing one of these situations and you need help from an attorney, please feel free to hit me up so I can refer you to an attorney service, and you would talk to an attorney that is in your state that could guide you through these items. But always make sure you send out a debt validation letter. You always want to start there, and also seek guidance from an attorney. So thank you for all of you that tune in. I really appreciate that. Diamond Life, thank you. I truly appreciate you guys for really rocking with the channel. If y'all need more information, feel free to hit me up. Be blessed.